Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Fellow justices, guests, counsel in this morning's cases, I'm Justice William Meade. I have the honor of presiding on today's induction ceremony. Our Chief Justice, Mark Green, could not be here. He's away someplace warm in a judicial conference. Actually, I think it's in Buffalo. But he sends his congratulations to Justice Hodgins and his family. The Chief's decision to leave me in charge is something akin to a parent going on vacation and leaving their teenage son with the house and car keys. So what could possibly go wrong? Okay, on to the good stuff. It's my great pleasure this morning to welcome our newest member of the Appeals Court, Associate Justice Christopher P. Hodgins, who was sworn in earlier this morning by Governor Baker's Chief Legal Counsel, Bob Ross. I want to welcome many of Justice Hodgins' friends, but especially I want to welcome his family, including his wife, Deb, his mom, his brother, his 5 children, aunts, uncles, cousins, nieces, nephews. Some of them are in the overflow room, maybe. Joining me on the bench today, in addition to our newly minted justice, are Justice Gregory Massing, Justice Eric Nyman, and Justice Suk-Young Shin. By tradition, the Appeals Court employs a 5-judge panel for initial first sitting, for a judge, and then the remaining cases will be heard by a 3-judge panel consisting of Justices Nyman, Shin, and Hodgins. Justice Hodgins graduated from the College of Holy Cross in the wonderful city of Worcester with a degree in history. He earned his Juris Doctorate from the New England School of Law in 1992, cum laude, and he served as the coordinating editor for the New England Journal of Criminal and Civil Confinement. He was born and raised in Milford and now resides with his family in Hopedale, Massachusetts. After his graduation from law school, Justice Hodgins began his career as a law clerk at the Milford District Court and then for the FDIC. He's going to help us with our taxes. From there, he went on to become an assistant district attorney in the Worcester DA's office, prosecuting hundreds of cases in district court and superior court, as well as arguing cases here in the appeals court and in the SJC. From 2002 to 2007, he served as chief of appeals in the Worcester DA's office. From 2018 to the present, he served as chief of the DA's Litigation Integrity Division. In that role, he was responsible for establishing professional and ethical trial standards, providing continuing legal education, and investigation compliance issues with police and prosecutors. Outside the law, Justice Hodgins is chairman of the Hopedale Zoning Board of Appeals, and he has coached youth baseball, basketball, and soccer. He is currently a member of the Worcester Bar Association. He's previously served as moderator for the Sacred Heart Parish Council, the Hopedale Regional School District Planning Committee, the Milford Town Government Study Committee, and he was an elected member of the Milford Town Meeting. I'm not sure how he had time to practice law doing all those things. Here at the Appeals Court, we follow the tradition used in the Superior Court of numbering our seats in the order that they were created. Justice Hodgins is occupying seat number 18, which was created as part of an expansion of this court in 2001, and was previously held by Justices Janice Barry and Justice James Lemire, a son of Worcester himself. We should also note that if you count all of the justices, including the recall justices, Justice Hodgins is the 80th person to serve on the Massachusetts Appeals Court. It's an honor and a privilege to welcome Justice Christopher P. Hodgins to the Massachusetts Appeals Court. And I invite you all to rise with me and welcome our new colleague. I will now ask our clerk of the Appeals Court, Joseph Stanton, to read Justice Hodgins' commission.
To all to whom these presents shall come, greeting. Know ye that we, by our governor, with the advice and consent of our counsel, confiding in the ability, discretion, and integrity of Christopher P. Hodgins of Hopedale, do hereby, under the provisions of Chapter 211A of the General Laws, as most recently amended, and in conformity with our Constitution, constitute and appoint him to be one of the Associate Justices of the Appeals Court, to hold said trust during his good behavior therein, unless removed therefrom in the manner provided by our Constitution. And we do authorize and enjoin him, the said Christopher P. Hodgins, to execute and perform all the duties, and he is invested with all the powers and responsibilities which, by our Constitution and laws, do or may pertain to the said office, so long as he shall hold the same by virtue of these presents. Witness His Excellency Charles D. Baker, our Governor, and our great seal hereunto affixed at Boston this first day of December in the year of our Lord 2022, and of the independence of the United States 246.
Thank you, Mr. Clerk. That ends the fancy part of today's ceremony. If anyone doesn't want to stay to hear the beginning of the cases, we're going to pause for a short bit and let those folks leave the courtroom. Thank you.
Appreciate it.
Thank you.
I almost sat in this chair when I came in, and I was wondering, why is Greg standing in that chair?
Yeah, it's a little bit, I couldn't actually tell where.
Yeah, I was confused.
Okay. Our first case is 21P 1000, Commonwealth versus Minion. Mr. Gauthier. Hope you had a chance to warm up.
Good morning, members of the panel. May it please the court, for the record, my name is Edward Gauthier. I'm here today to argue on behalf of the defendant appellant Nicholas Minen. Mr. Minen was convicted by guilty plea of sexually assaulting his stepdaughter. He filed a Rule 30 motion to withdraw his plea because he received erroneous legal advice from counsel as well as the court. The motion was denied, and the judge in the denial cites a decision of this court from 2005, Commonwealth v. Schindel, which held that sex offender registration is a collateral consequence, and therefore trial counsel cannot be held to be ineffective for failing to provide the proper advice. However, in 2016, in Commonwealth v. Sylvester, the Supreme Judicial Court ruled that the failure to advise an individual of the sex offender registration consequences of a guilty plea can be subject to the Padilla framework in Padilla v. Kentucky, where we look at three things. We look at whether it's a direct consequence, and the SJC did find that sex offender consequences are a direct consequence. They also look at prong 3, which is whether there's any statutory recognition of the need for warnings, and the SJC did find that. The only other factor is factor 2, and the SJC found that the sex offender consequences in 2002 were not so severe that failure to give those warnings required a new trial. However, in this case, we have a 2017 guilty plea. A lot of things have changed with the sex offender registry laws since 2002, which...
What hasn't changed is Chapter 6, Section 178E, Subpart D.
Yes. The statute says that failing to advise a defendant of the sex offender consequences of a guilty plea cannot be the basis of the plea. However, a statute cannot usurp either the state or the federal constitution. And if the statute forbade a Rule 30 motion in these circumstances, Sylvester would have simply cited to the statute and would have denied relief in that case. But they didn't. They applied the three-pronged framework, and it held for a different day, and I hope that day is today, for a determination under the state and federal constitution's due process clause, as well as the right to the effective assistance of counsel, that failure to give this advice requires, in certain circumstances, that the individual be allowed to withdraw his plea.
Can I just ask you a framework question? In order for your client to prevail, you've got to satisfy the Padilla three-part test, right? You have to, including that it would have been rational to go to trial. And then if you convince us of that, then you also have to convince us to overrule Schindel, right? Is that?
Well, all Rule 30 motions have a two-part analysis. First is whether the constitutional right was violated, and second, whether there was prejudice. So we first have to establish that this court should overrule Schindel, and we're arguing that the court should do that based on Sylvester. If the court does that, we go to the second prong of the analysis, which is, was there prejudice in this case? And under Commonwealth v. Clark is 2011's the seminal case on prejudice. But in this case, the court didn't actually reach the second prong. The court didn't analyze prejudice. What the court did was it cited to Schindel, and it cited to the statute, and it found as a matter of law, because of Schindel, which is a finding that sex offender registration is a collateral consequence, and the statute says that you cannot withdraw a guilty plea based on failure to get the advice. The court at the trial level in this case decided it there on the first prong. Did not reach the issue of prejudice and did not reach the issue.
So on the first prong, the changes you identify from 2002 till now, it seems all relate to offenders who come back as level 2 or level 3.
Yes, Your Honor.
But the only error here was advising on the consequences of what would happen if he came back as a level 1. So isn't that the lens through which we have to view this case?
Well, essentially the court made a promise to my client. The court told my client that if he came back as a level 1, that he would be relieved of his obligation to register.
Right, so that was the error. But wouldn't we have to find that the consequences of having to register as a level 1 are so severe that it implicates the Sixth Amendment? Why do we even look at the differences in the scheme for level 2 and level 3?
Because my client was finally classified as a level 2 sex offender, and he
got accurate advice as far as what would happen if he did come back as a level 2.
He was induced into waiving his very critical constitutional rights to a jury trial. A jury trial was the only way that my client was going to avoid registration. And the record is very clear in this case. The DA, the defense counsel, the judge, all understood that what was holding back a guilty plea in this case was the fact that my client did not want to have to register as a sex offender.
The counsel, didn't defense counsel during the plea hearing tell the judge that the defendant never wanted a trial, didn't want to put his kids through it?
Your Honor, as a defense counsel with 14 years of experience before the district and superior courts, I can tell you that we say those things all the time. Those things are not necessarily true. We say things during plea colloquies in particular to bolster our client's legal position. I don't believe that anything can be taken from the statement of defense counsel during the plea hearing, where he's essentially discussing why the court should give leniency.
Well, could the judge have credited it, though, right?
The judge could have credited that for certain, but the judge doesn't mention that. The judge, in his decision in this case, in his margin notation, he doesn't do a few things. He doesn't make any credibility determinations. So we have an affidavit from trial counsel and we have an affidavit from the defendant, and the judge in this case does not credit or discredit that. Secondly, the judge doesn't make any factual findings. The judge makes a legal determination based on the statute, and based on Schindel, that relief is not possible in this case because sex offender registration is a collateral consequence. That's the decision that is before the panel. And I understand in the Commonwealth's brief they focus on the prejudice, whether there was prejudice in this case, but the judge didn't reach that. So if the court decides, the first issue in our favor, if the court decides that sex offender registration consequences are sufficiently severe that we have to go to prong 2, then I would suggest that the case would have to be remanded for 2 reasons. One, to determine whether the plea was willing, knowing, and voluntary. The judge did not make that decision, and the judge also did not make any decision on prong 2 prejudice. And I don't believe that the court should step in the role of the trial judge who is in the best position to make a decision on
Except
prejudice.
that neither affidavit of either the defendant or plea counsel says that had the defendant known that by pleading guilty he would have to register, even if he came back as a level 1, he would have gone to trial. I mean, that's really the only question here. The consequences of having to register as a level 1 are relatively minor, right? I mean, his information would only go to the police department. So wouldn't you have the initial burden of establishing that had he known that if he was classified as level 1, his information would be given to the local police department, he would have chosen to go to trial. And that's not what the affidavit says. It says, if I was aware that by pleading guilty I would have to register as a sex offender for life, which actually I don't think is accurate, it's not for life, he would have gone to trial.
Your Honor, the part of the sex offender registry law that requires lifetime registration for those convicted of sexual offenses against children has actually been declared unconstitutional. So he is entitled to a hearing. But his affidavit clearly says that if he knew he was going to have to register as a sex offender as a mandatory penalty as a result of tendering his guilty plea, he would not have pled guilty. He would have insisted on exercising his constitutional right to a jury trial.
But didn't the judge ask him if you understand that if you come back as a level 2 after the evaluation, then you have to register? And he said he understood.
He understood that if there was an evaluation, and I understand the Commonwealth's position that my client got so-called the benefit of the bargain, that he was presented with an option by his counsel and by the judge that if he came back as something other than a nominal or low risk, that the judge would not relieve him. But in the end, that was an illusory promise. The judge didn't have the power to do that. What we had here is a client, a defendant, who was insistent on the day of trial
The
of going to
condition
trial.
preceding was never realized.
It was not. He was not.
So it's not illusory at all. It's quite follows logically.
It's an illusory promise, Your Honor, because the trial judge had no actual power to do what he promised to do in the event the client came back as a low risk. No matter what happened with the evaluation, the client was going to have to register as a sex offender, period, under the law. What the judge offered him to induce his plea and what trial counsel offered my client to induce his plea was not a possibility. My client has a right to only plead guilty when it is a knowing, intelligent waiver of his constitutional right to a trial, and this cannot be said to have been knowing and intelligent when he tendered a plea.
But the defendant would have the burden of showing that the consequences of having to register as a level 1 were so important to him that had he known that would be the result of pleading guilty, he would have gone to trial. Right, because the error only relates to what would happen if he came back as a level 1. So where in the affidavit does it say that he would have gone to trial had he been accurately instructed about level 1 registration?
So we're using the term level 1, level 2, and level 3 because my client was ultimately found to be a moderate risk level 2 sex offender, but that's not actually what the agreement was between him and the judge.
That was actually my question. The agreement was for
An evaluation.
the judge ordered your client to undergo a sex offender evaluation. And my question is, was it clear from context that that evaluation meant undergo SORB classification? Or did it mean go find an expert, have an evaluation, and come back to us as the judge ordered with your information.
So during the plea hearing, defense counsel offered to get funds, $1,500 to have an evaluation. And the judge said so whether my client had to register or not, or was relieved by the judge, had nothing to do with sex offender registration. It had to do with the results of the evaluation.
Did your client get an evaluation?
It's not in the record, Your Honor, but I
Not in
think...
the record, then we don't need to hear it, but did your client or did defense counsel, plea counsel, present the plea judge with the results of an evaluation?
No, Your Honor, and
The judge said it's incumbent upon you to do this, and I'm looking at the plea transcript at page 41, and the judge reminded your client that it is incumbent upon you to bring it before the court regarding the registry issue.
That is correct, Your Honor. The trial counsel was instructed to bring the case back if and only if an evaluation led to a finding by the evaluator, the expert, that the client was a nominal or low risk. So
without the evaluation, how do you satisfy the prejudice point? In other words, the judge gave an opportunity and your client couldn't satisfy the opportunity.
No, Your Honor, he couldn't satisfy the opportunity because the judge had no statutory authority to relieve him his obligation. Regardless of what that report says, whether that evaluation by the expert says low risk, moderate risk, high risk, incredibly risk, it really doesn't matter because no matter what the evaluation says, any action the judge took based on that evaluation would have no legal authority. But I think...
But had an evaluation come back that said this person is absolutely no risk to reoffend and is not a danger, and that had been presented to the trial judge, your argument might lie on a different footing right now, correct?
I don't think it would, because even if he came back as a no risk, the judge would have no authority to relieve him of his obligation to register. So the obligation, the judge, I just want to make...
The judge could have made a determination that the plea wasn't knowing, voluntary, and intelligent had that come before the judge.
The judge did not make a decision regarding the voluntariness of the plea.
What is there about the voluntariness of the plea other than this advice?
Well, this is not a case where the client got no advice. This is a case where the judge, defense counsel, and the prosecutor recognized that my client didn't want a plea, and they fashioned a workaround.
No, really easy question. What is the basis of that it's not knowing and intelligent? Just this thing?
He was induced based on misadvice, not just no advice, but he was induced over his will to plead guilty based on faulty legal advice. I see that the red light is blinking, indicating my time is up, so if the panel has no further questions,
Seeing none.
We would rest on our brief. Thank you.
Thank you. Ms. Campbell.
Good morning. May it please the court, Julianne Campbell on behalf of the Commonwealth. I'm asking that this court affirm the denial of the defendant's motion for new trial. I respectfully disagree with my brother's contention that this court must first decide to overrule Schindel before addressing the prejudice prong, and I turn to Lastowski, which was also decided in 2018 and candidly argued by my brother. And in that case, the SJC left for another day. At issue was whether a 2014 version of the SORB registration requirements, whether that was required competent advice from counsel on the sex offender registration issue. And in 2018, in considering that 2014 version of the statute, the SJC, Justice Kafka, I believe, wrote the opinion, wrote that we need not address that today because we can resolve this on the prejudice issue. And quite simply here, the defendant falls incredibly short on establishing the second prong of the ineffective assistance claim.
Counsel, does the Schindel case even apply here? Because didn't that case involve a failure to provide any advice, where in this case, it's not a matter of failing to provide advice. It's a judge providing incorrect information and counsel misadvising.
And I don't disagree with that, Your Honor. I recognize that that was incorrect advice. However, it's the defendant's burden at a motion for new trial to establish that he would not have pled guilty but for that advice, and that it would have been rational to reject the plea. And here, he cannot meet that burden, and he did not meet that burden below. The reason for that, as this court inquired of my brother, is that, quite frankly, the incorrect advice he received was not the harm, there was no harm suffered from that, because he was throughout the plea advised, if you're a moderate or high risk, you're going to have to register. That was made very clear. This defendant was labeled a moderate risk. There simply was no prejudice.
But when we go back in time to the day that he decided to plead guilty, wouldn't he still have a claim, whether he's proved it or not, but wouldn't he still have a claim that had I known that I'd have to register even if I did come back as a low risk, I would have chosen to go to trial because the consequences of registration were so important to me?
He can certainly make that claim. However, it's also his burden to establish that it would have been rational under the circumstances to reject the plea that was offered. And here, given...
So, sorry to interrupt, but so then how does his later evaluation, coming back as a moderate risk, how does that factor into the prejudice analysis, if we're going back to the day that he pleaded guilty?
So if the day that he pled guilty, if his concern, I'm sorry, can Your Honor ask the question again?
I take his claim to be that had he been accurately instructed on the consequences of,
Sure.
even if his evaluation had come back as low risk, that was so important to him, he would have gone to trial instead of pleading guilty on that day. So my question is, when the evaluation later comes back as a moderate risk, how does that factor into the prejudice analysis?
So the way that I think that I'm not asking that, well, I am in one hand, I'm arguing that he doesn't suffer prejudice because the benefit that was offered to him never came to fruition. So that is one argument that I'm making. But as to your question, the reason I don't think he satisfied his burden is because even if he had gotten correct advice that you're going to have to register, it would not have been rational under these circumstances, given the nature of the offenses that he was charged with, given that the judge indicated that jail time was appropriate, given that the Commonwealth was asking for a 2.5-year sentence in the House of Correction, that the Commonwealth was ready with a 14-year-old child witness to testify to the sexual assault allegations, that the defendant was not entitled to a quaff, as he argued in his motion below, and the fact that there is no proffer of a defense anywhere, not at the plea, not at the motion for new trial, not in the affidavits accompanying it. The defendant affirms that he gave information to defense counsel about a defense, but defense counsel makes no mention of what the defense may have been.
Was the rape count null prost as part of the deal or something separate?
I can't answer that off the top of my head. I apologize to the court for that. My recollection is that the docket reveals earlier in time it had been,
Okay.
but that's just my recollection. I would rely on the docket. But given all of the factors at play here, the second prong of the prejudice analysis is that it would be rational to reject the plea. And here, given all of that, he had no ground of defense. He had no possibility of a better agreement. And the circumstances at issue with respect to the level 1 classification, as Justice Shin pointed out, and are referenced in Lastowski, those are not the type of special circumstances that warrant, in the context of the sex offender registration advice, that warrant a finding of prejudice here.
Assume for purposes of this question that the evaluation ordered by the judge was something separate from a SORB classification.
Sure.
Assume that the evaluation came back favorably to the defendant and said he's of no risk,
Sure.
et cetera. And he presented that to the judge as the judge had ordered. while the judge could not have ordered no registration, could the judge at that time have determined that the plea was not knowing, voluntary, and intelligent, and allowed him to withdraw the plea on that basis? Would that have been within the judge's power?
That's a difficult question for me to answer.
Well, we try not to just give softballs.
No, I appreciate that. I don't want to not answer your hypothetical. I would like to distinguish by saying that here, obviously that's not what happened, and I agree that the defendant would have a much more compelling case if that is how this played out. But it's not, and in reference to your hypothetical, I think there would still have to be a showing as to how that impacted the voluntariness of the plea, because when we look at a knowing involuntary plea, we're talking about often a compulsion to plea, an inducement to plea, some type of coercion. That's not at case here, and I'm not sure that this would necessarily rise to the level of coercion that is typically understood in.
I mean, and if Schindel is right, then you're not even entitled to any advice about sex offender registration.
Correct.
And you're saying, even in Justice Nyman's hypothetical, it wouldn't have been rational at that point for him to withdraw his plea, right? So the evaluation comes back as no risk. At that point, he's probably thinking, all right, I'm going to be classified as a level 1, and here are the consequences of a level 1 classification. And I take your argument to be, it wouldn't have been, those consequences are not severe enough for it to be rational for him to go to trial.
Correct. That's correct.
Can we make all these determinations ourselves when the judge didn't reach them?
So, well, first, I think the judge applied the law correctly as it exists currently. There's no error of law in the judge's decision. I think implicit in the judge's decision is that there is no prejudice. And I think that this court is free to affirm a decision of a lower court by any reason that's apparent on the record. And here, even in the defendant's brief, and even before the court, I think he struggles to satisfy not only that he suffered prejudice, and specifically that it would have been rational under the circumstances to reject the plea. Unless there are any.
We have one more academic question.
Sure.
And I hope this doesn't give you PTSD back to your days taking criminal procedure. But in Hill versus Lockhart, the Supreme Court of the United States said that they left open the possibility that if a guy had been incorrectly advised about the collateral consequences of I think it was parole eligibility, he'd have to allege that I would not have pled guilty except for parole eligibility. And they seem to think if he had made those allegations, that would have been a good claim of ineffective assistance. If as in Padilla later, if it really would have made a difference. Why shouldn't bad advice about sex offender registration be considered?
So I would, I mean, my fallback position is frankly that Schindel and the cases after, which do not overrule Schindel, stands for the fact that it is a collateral consequence and that it is not central to the plea. And that's the case law that I would rely on.
Well, the statute says it too.
Correct.
And as I understand, Mr. Gauthier is making a constitutional challenge to the operability of the statute. And or a facial challenge, I guess. Was that facial challenge made below?
I'm trying to recall the specifics of the motions as filed, and I apologize to the court. I don't recall the answer to that.
Okay, thank you.
Now, the difficulty I have is, well, it may all be true that it's a collateral consequence. In this case, it really wasn't collateral, was it? Because this was something that was important to this defendant who's coming in. He suffers from PTSD. He's a war veteran. He's 100% disabled. He's relying on his lawyer. His lawyer is misadvising him. The judge is misinforming him. Doesn't all of this make this something more than a collateral matter? That isn't this something that's important to him?
So my response to that is primarily that if in Lastowski, the SJC discusses that the general concern about a face appearing online, about registration, generally is not sufficient to establish special circumstances that I think would imbue this so central to the plea, similar to the way that immigration is so central to the criminal effects. So in Sylvester, the SJC talks about this, how what Padilla stood for was simply that immigration consequences were not collateral. And I understand the question that doesn't this seem more than collateral to him? First, as a matter of law, it's collateral. Second, I would say that the concerns he had, and this speaks to Justice Shin's questions earlier, I think to my brother, about the level 1 requirements versus level 2 and level 3. The level 1 requirements that he got bad advice about, I would suggest, are not significant enough, based on Lastowski, to establish that this is anything other than a collateral consequence of a plea, because the level 1 registration requirements are comparatively minimal. And I would suggest that in Lastowski, where there are not special circumstances sufficient to rise to render it more than a collateral consequence, that here it can also not be more than a collateral consequence. Seeing no further questions, I'm happy to rest on my brief.
Thank you. Thank you both. We're going to take a short recess so the panel can